Zipatia kipaumbele. Unatupata mbashara kupitia mitandao yetu yote ya kijamii TV47, YouTube, Facebook na pia X. Jina langu ni Ruga Ival. Hujambo na karibu. Mbunge wa Naivasha Jayne Kihara amefikishwa katika mahakama ya Milimani anakotarajiwa kujibu mashtaka ya uchochezi. Kihara alikamatwa Alhamisi nyumbani kwake Naivasha na maafisa wa DCI na kufikishwa katika makao makuu ya DCI na kisha kuzuiliwa katika kituo cha polisi cha Pangani. Tuvuke moja kwa moja hadi mahakamani tutazame yanayojiri.
Clause 3 paragraph B of the Constitution and the pecuniary limitations set out under section 7 subsection 1 of the Magistrates Court Act, the Magistrate Court shall have jurisdiction to hear and determine applications for redress of a denial, violation or infringement of or threat to a right or fundamental freedom in the Bill of Rights. So the Bill of Rights, Your Honor, as per section 8, is squarely under your jurisdiction to determine either denial, a violation or infringement, or a threat to a right or a fundamental freedom. So, you know, when we invoke Article 33, Your Honor, it is so squarely rightly before you to determine whether or not this charge sheet borders between a denial, a violation or infringement of a right, a threat to a right, or fundamental freedoms. We address you on the basis that the section under which this charge sheet has been premised, that is section 94 subsection 1, was enacted in 1930 with the commencement date being the 1st of August 1930. It follows, therefore, Your Honor, that with the enactment of the new Constitution, the ODPP, who has brought us here this morning, ought to have been alive to the provision of Section 7 to the 6th schedule to the Constitution. Section 7 to the 6th schedule, Your Honor, to the Constitution provides that all laws that were in effect before the effective date shall be read with the necessary modification, adaptation, alterations so as to bring it into conformity with the provision of the Constitution. And while I am not inviting you to look at the constitutionality of that section, I am inviting you to look at whether or not the application of that section falls within the provision of Section 8 of the Magistrates Court Act. And I want to make it clear so that my learned friends on the other side may understand that I'm not invoking your jurisdiction to determine the constitutionality. I'm invoking your jurisdiction to determine the applicability of that provision. Therefore, in that sense, Your Honor, Section 94, subsection 1 must be brought within the ambit of Section 7 to the 6th schedule. And the reason why the drafters of the Constitution made a proviso to save the existing laws before the effective date was to make sure that, Your Honor, that granted the circumstances that Parliament is not able to address all laws so as to bring it to conformity, that the application of such a section may not result into violation of a provision under the Constitution. That is the reason why we have the existing, the clause saving the existing laws before the effective dates, and hence the enactment of Section 7. Having said that, Your Honor, Section 3 tells you that you must address yourself to Article 10 of the Constitution. And what are you addressing yourself to Article 10? Article 10, subsection clause 1, provides that Article 10 binds all state organs or even persons whenever any of them is either implementing the law, legislating the law, or formulating any policy. In this case, Your Honor, you are implementing the law. And therefore, you are bound by the provisions of Article 10, which lays down the national values and principles of governance. Among those values, Your Honor, is a value of human right. That human rights binds you. And that is why Section 8 of the Magistrates Court Act, in cognizance of the fact that you are bound by Article 10, has deliberately given you that jurisdiction. Because it is not possible, therefore, for the Constitution to say that Article 10 binds you holistically without any possibility of waiver. And then
you have no powers to amend laws. That power belongs to Parliament. That Parliament, which is inept and or negligent, in the words of the defense, is the only authority under this Constitution to make, amend, or repeal laws. And related to that, therefore, is that as long as that law has not been repealed, it remains part of the law of Kenya. And if that argument is correct, and I believe it is correct, then the argument about Article 50, sub-Article 2N, which is a very easy one to answer as we go on, that every accused person has a right not to be tried for an offense in respect of an act or omission, N, not to be convicted for an act or omission that at the time it was committed or omitted was not an offense in Kenya. This offense is an offense in Kenya since 1980. So until it is repealed, this court and the Office of the Director of Public Prosecutions has an obligation to enforce the law. There were very many fundamental issues of the Constitution, that's why I've taken some time on it. Then there is the question about Article 52B, which I'll marry with what I've just said about 52N. Your Honor, I have tried to persuade other benches of the judiciary, and I will try to persuade you today, that there was a deliberate intention to separate Article 49 and Article 50 of the Constitution. This is what I teach my law students at the Kenya School of Law in my guest lectures. That it was deliberate to separate the rights of an arrested person vis-a-vis the rights of an accused person from a commonsensical look of the Constitution. So that when senior counsel started giving his opening speech, he says, no, I should not call her accused, let me call her suspect for now. And which I agree with, that we are dealing with a suspect, not an accused person. Then that, if I persuade you, takes you outside Article 50 of the Constitution, which is the rights of an accused person. So that, in other words, we're saying the rights under Article 50 are triggered upon the taking of plea. That argument may not be correct, but we are trying to persuade you that it is correct. And I hope we are right. Because it is this court that makes that determination. So then we have dealt with Article 52, Article 52B and 2N. We agree with our colleagues on the application of Article 25, that it cannot be limited by all means. But having spoken about the limitation of rights, as my learned colleague, again in his element, I pointed out, there is the possibility of limitation of rights outside Article 25 by dint of Article 24 of the Constitution, that it permits